do I only need to complete Form 982 at tax time? Or would I receive a 1099 if the lender has waived deficiency rights?
I would expect if the lender has waived the deficiency, I would expect to receive a 1099. I'm not a CPA. I'm not a tax attorney. What I would encourage anyone to do, even if it is a primary residence, and I think that they're going to be exempt from the 1099 tax liability, would be to, when you receive that, whether it's your customary practice or not in regard to your taxes, to go to a CPA or tax attorney, describe the terms of the mortgage workout that you entered into, show them the 1099, provide the information that you have, whether it's a declaration of domicile or utility bills, voter registration, driver's license, that indicates that this was a primary residence, and follow their guidance. And I'm sure that they will advise you of the proper tax forms to fill out so that you take advantage of the Mortgage Debt Relief Forgiveness Act and do not have to pay the forgiven debt income tax liability.
And Jason, we had Rick Donner on our webinar yesterday. He's a CPA in Fort Myers.
Okay.
There are, we went over it yesterday, but there are a lot of situations where, for whatever reason, 1099s aren't issued, but legally it's still forgiven debt, and you might be able to balance that off with your taxes, but you legally still have to report that as forgiven debt income. It might be able to, you have other debt, balance that off, but it still legally needs to be reported. Does that?
Yes, it makes sense to me if you have a written agreement that there's been a deficiency waiver, because then you're aware of it. You have something in writing that would be enforceable, saying that the lender has forgiven us debt. So I would absolutely defer to his tax advice on that point. However, the other situation which arises, which I think it would be important, this is a legal distinction that, having received Rick Donner's advice, I would say you want to acknowledge this legal distinction and make sure that you report this to a CPA as well. If you do a short sale and the lender says, we're going to agree to release our lien in exchange for receipt of the net closing proceeds of this short sale, we will contact you within 30 days to discuss satisfaction of the deficiency. All right? 30 days go by. Bank doesn't contact you. The remainder of the tax year goes by. Bank doesn't contact you. I would encourage someone to talk to their CPA, but you would want to tell them this debt has not been forgiven. It just hasn't been enforced, because the lender has 5 years in which to enforce their rights to a deficiency. So, even if you have not received the 1099, before you tell your CPA that you have had debt forgiven, make sure that debt has actually been forgiven, and that this isn't simply a situation where the bank has reserved their rights but has taken no action for you, because they have 5 years in which to take an action.
Very important distinction, isn't it?
Yes.
So after 5 years, they have not gone after you for the deficiency judgment. Do you then have to report it as income?
That's an excellent question for Rick Donner for your CPA, because the question would be, they're now simply barred by statute of limitations. So when a person's claim is barred by statute of limitations, is it really forgiven? That's a Rick Donner question. I don't give tax advice. I would say, from a legal perspective, my opinion, under issues of claim for it is barred. So I'd say there's a distinction there, and that may be a distinction that carries through to the tax code, and it may not be taxable. But I would absolutely say then you talk to your CPA and say, I did a short sale 5 years ago. I received their approval. They released their lien. They did not waive the deficiency, but my attorney now says that by statute of limitations, they're barred from collecting. Do I have to report that as forgiven debt income? And excellent question for CPA. And they might bring in a tax attorney or even consult with your real estate attorney to ask about the issues of the statute of limitations and how that affects any type of collection activity to make that determination. I suspect that no, that's different than forgiven debt.
Interesting, very interesting. Okay, next question, Jason. Legally, what are the advantages of a short sale over a foreclosure?
I'd say that I don't know that there's necessarily, a legal advantage. I think there's a financial advantage, and there's a credit reporting advantage. There's a financial advantage to both the lender and the borrower in that you're getting probably what is the closest approximation to fair market value through a short sale. I think the reality is that people may not make their absolute highest, best purchase offers when a property is in a short sale because they know they will very likely have to wait out a long lender approval. So sometimes people hold back a little bit. But it's almost certainly better than the proceeds that are going to come at a foreclosure auction, where typically the lender purchases the property back because no one bids the property up to the amount owed on the mortgage. And people frequently don't make their best offers on bank-owned REO properties also because people frequently have title concerns on bank-owned properties. So I think the financial benefit would be if there's no foreclosure judgment. As soon as the short sale closes, the foreclosure action is going to be voluntarily dismissed. So the legal consequences and the attorney's fees that would be added on to the judgment and the accrual of default rate interest ends. Those are all financial benefits to the borrower. It's going to be reported to credit reporting agencies as settled for less than amount owed by agreement with lender, which I think is generally is a better. It's not a positive credit entry, but it's better than foreclosed. A borrower will recover more quickly in terms of credit reporting from that entry than foreclosure, which in addition to being reported as a derogatory entry on account, is also reported as a public record and is going to be pulled up in the public record section of a credit report, whereas otherwise there'd be a voluntary dismissal that's part of public record. So I think that it's a benefit in that respect. If the borrower is represented in the foreclosure process, they're going to be done sooner. They're not going to be paying attorney fees for their attorney anymore. So I think there are many benefits. From the legal standpoint, there's not much difference, and I'd say there's not much difference because all a foreclosure does is provide clear title to the lender. All the short sale does is provide clear title to the ultimate purchaser, who the bank would end up, that person or a person like them is who the bank would end up selling to ultimately anyway.